Oh, sure. I'm very happy to be here. I've been here for 3 or 4 weeks now teaching at Tel Aviv, and it's so nice to see all of you. Benny asked me to give a paper, and I sent him this one, and he said yes, which I was rather surprised at, because it's a pretty technical paper, and it has pretty much the blandest title you can see. But it does have some ramifications and issues in a relation to what we're talking about today in terms of corporate purpose. And I think one of the things that we talk about when we talk about corporate purpose and ESG generally is how we measure these issues. And so we all know that endogeneity is a religion these days, and we are constantly trying to find ways to measure the value of corporate governance. And the thing that we're going to look at here, which is related to some work I've done in other papers with Yaakov Amahud and others, is whether these identifiers actually work. And so Ian Appel in 2019 came out with a paper that talks about universal demand laws as a use for an identifier. I want to say something. I really value Ian, and I think he's a terrific academic. I think this is a great paper in the sense that it makes a contribution. And I wish he was here so I could tell him that. But what we're going to do is we're going to look at this and whether it's an effective identifier. And the idea behind this is basically one of the issues that we have all the time in ESG and finance generally, which is a great frustration to law professors and people who are institutionalists, which is what is the channel and what's the theoretical benefit to what we have. And so, you can publish in the Journal of Finance a paper called The Vote is Cast and find out that, close votes result in firms getting 10% performance in the next few years, but really, who cares about these shareholder proposals about who's the board chair and otherwise, and what's the relation theoretically to where we're going. And so I think one of the things that we want to do is for universal demand laws is look at what the effect is. Basically, universal demand laws are in the depths of corporate governance, which is basically if shareholders are going to sue, they need to make a demand on the firm. And there are various exceptions around them, various ways around them. Certain states, starting back in the 1990s, began to pass laws which said you always have to make a universal demand on the company, right? And the obvious issue here is they're designed to deter litigation. So you go to a company, you say, so-and-so, your CEO has breached his or her fiduciary duties, we want you to sue them, and we're asking you to sue them. And they're less likely to do that than if you could just bring the suit directly, right? They're more likely to protect their own managers. And so there are governance effects, but you can have postulations either way. One is they'll deter frivolous lawsuits, another is they'll result in further board entrenchment. And so you have varying effects of what the channel is on UD laws, and also whether they relate to governance. So, is a firm going to be run better or not if they can be sued for breach of fiduciary duty, and how is it related to other metrics that we use? And so we raise the possibility here that I've explored in other papers about staggered boards and otherwise that maybe we're mismeasuring what's going on, and maybe we're using the wrong measures to begin with, okay? And so I'm going to skip the institute. Here. Okay, and so the idea behind this is we're building on a series of papers which is really stepping back and saying maybe this is all endogenous, maybe this is not. Are the identifiers that we're actually using to measure good corporate governance actually working? And so what we're going to do is we're going to use this to examine the use of the E index generally in terms of looking at corporate governance measures and the effect of that. And the second is we're going to look at not just the E index, but how it's calculated, whether it's a good measurement generally, which has been addressed by a couple of papers, including by Larker, and most recently Eric Talley has a paper on this. And then the second thing is we're going to look at, this religion of endogeneity that we have, which is important. I don't want to overstate it, but are we overusing identifiers and small sample sizes and insignificant variation in effects to find results that we like. I have to say I have stakes in both of these. I have a JFE paper on state anti-takeover laws, which uses them as an identifier. I have a paper with Yaakov Amahud where we look at staggered boards and we come out the other way. So I'm a bit schizophrenic here. It's probably about corporate purpose with Jill Fish, and also where we actually believe in corporate purpose, but I'm sounding skeptical today about corporate purpose. So someday I'll figure myself out, and I'm sure there's something there. But the other thing is, and I really want to emphasize this, is what is the channel? So I think one of the criticisms that I've had throughout my career from the institutional perspective is you see a lot of finance papers with clever identification strategies and no theoretical foundation. And if you actually look at the institutional mechanisms of it, it just doesn't make sense. It just doesn't make sense that universal demand laws would increase value because they really have very little to do with the governance of the company. Okay? And so this is also something that we've seen in the poison pill and other governance mechanisms and otherwise. Okay, so what do we find? Basically what we're going to do, and I'll run through this more deliberately, is we're basically just going to do a standard difference in difference structure. There have been some good developments on this that I'll talk about. Holder-Spamann has a good one about using sample size with where Delaware is the most significant N and how to adjust for that. And basically what we're going to do is we're going to compare states with demand laws versus states without demand laws and look to see what the effect of these provisions are, okay? And so we're going to actually see, we're going to dig into Apple's study, right? And the other thing is, which is sort of maddening, because Apple found this identifier, there's now about 19 or 20 papers using this identifier, including in the JAE, like top tier finance and accounting journals using this identifier. So the question really is, does it really work from a corporate governance perspective, which is the foundation of it, which is what Apple looks at. So we're just going to do a 2x2 research design, and what we're going to do is look at changes in the use of the entrenchment provisions before and after the UD law adoption. And the way to think about this is what we're going to do is we're going to use the E index, right? And what the E index is it measures 6 governance provisions. It's been cited 13,000 times, and basically it's sort of like Tobin's Q. No one's found out something. We know it doesn't work, but we haven't found anything better. So we're using it to measure whether we have good governance or not. Okay, and basically our treated group is going to be the firms incorporated in UD law adopting states. Interestingly, this will come up in a little bit. Most of our treated firms are not just incorporated, they're headquartered in their states. That makes sense. So in the US, you're either headquartered, you're either incorporated in Delaware or you're incorporated in your home state, right? There's no real, there's a literature that was going on for 30 years about the race to the bottom, race to the top. It doesn't really exist. You either go to Delaware or your own firm, okay? And our control group includes firms incorporated in states that never adopted UD laws, and we're going to run that twice. We're going to drop, again, looking at Holder-Spamann's paper, and just to control for that issue, we're going to drop Delaware firms for the most part as we move forward. Okay, so we're going to get the, here's where it starts to get interesting. So again, we've been using the E index to measure corporate governance changes, right, including with ESG and corporate purpose. The E index was a survey of, I'm not even sure, it's about 1,500 firms. They've never really defined how they chose those firms, but basically the 1,500 largest firms that you have, and it happened every 2 to 3 years between 1990 and 2006, okay? There's miscoding in there. My paper with Yaakov looks at that, Larker's paper looks at it, Talley's paper looks at it. But even if you take it at face value, it basically looks at 6 provisions, which are classified board, supermajority voting, limits on shareholder bylaw and charter amendments, and can we restrict shareholder voting power, okay? There's also poison pills and golden parachutes. Again, I was a practicing lawyer for 10 years. from 1995 to 2004. I never really thought of these except for the poison pill and the staggered board. And so again, like, what are we really looking at here? But nonetheless, we have these issues, and what you can do is you can identify changes in the E index over time. Now, one of the things that we do is we're basically going to exploit the fact that the UD laws were adopted on specific dates, but pre-event and post-event ISS survey, we can look at when the actual changes to the governance metric was. So what Apple does is he basically says, do states with UD laws, do they become more, are they more entrenching post adoption of the UD laws, and is their value reduced? Okay, but what we can do is, because we have the pre-event and ISS survey and the post-event ISS survey, and because I'm a law professor and I can actually read the laws and know when they're passed, we can see, for example, Pennsylvania adopted a UD law on April 21st, 1997. Was the entrenching device that Apple links to a decline in value, was it actually adopted after the UD law or before the UD law, right? So that's a pretty simple mechanism, and what we're going to do is we're going to see is, I'm supposed to be talking here, and I'm 52 and I can't see anything anymore. And so what we're going to do here is we're going to look at whether if the causal effect we're identifying is actually related to the UD laws. And one way you can do that pretty simply is to see when did they actually adopt the entrenching provisions. If they adopted it before the UD laws, it's not causally related. Now, you can argue that they did it in anticipation, right? Which of course is absurd, but you could do that. That's a comment that you get on an R&R. But we're going to talk about that in a second, because this is on an R&R, so I have to answer that question. Okay, so, and in fact, that's a question we got. Prior work doesn't identify this issue, and so what we're going to do is we're just going to look at these issues. So let's actually look at some results. I have a slide just on the technicalities that we do. This is mainly with Panos Patatukis, who's in the accounting department at Haas. He does most of this stuff, and I try and understand it. But basically, this is what we're doing, which is a basic difference in difference, which we use a two-way fixed effect estimator on. Okay, so let's look at some numbers. So one of the things that we find is basically, which you would know if you were incorporated in Delaware, is outside of Delaware, there are incorporations, but there's not that many in some states, okay? So basically we identify the states where there's UD laws, okay? So there's 16 UD adopting law states. And then we're going to identify all the firms in there, okay, that are the treated firms. And what we find is, so for example, if you had a firm in Wyoming and it was incorporated in Delaware, that's not a treated firm, right? Because it's not subject to those demand laws, it's subject to Delaware demand laws. And what we do is we find there's actually 110 unique treated firms. 97 out of 107 firms are in-state incorporations, okay? We're going to exclude out Montana, New Hampshire, Arizona, and South Dakota. There are no firms there. And we're going to have to exclude out Georgia, Michigan, and Florida because it's prior to 1990. But we get our sample of approximately 110 firms. And basically, one of the other things we observe is that most of the firms, or at least 25%, are Pennsylvania firms. Which actually, again, Ed's going to nod again in agreement, because historically that's where a lot of firms were incorporated back in the day to what we see, okay? So we have 110 firms, 97 are in state and incorporated in state, and then what we're going to do is we're going to then look at this. We're then going to exclude out any firms that have less than 4 observations, because that's a really small N. And one of the things that we're going to see is then we're going to look at the frequency of treated firms using entrenchment provisions. Now, I want to point something out here that I probably should have pointed out before. If you look at the N's in Apple, it's thousands, tens of thousands, right? Because he's looking at the whole universe of public companies. But when you actually look at it, we have 20 firms that have changes in their entrenchment provisions which are driving his results, okay? And so this is another thing about these corporate governance studies, which is many times you're getting a very small n that's driving your result. And one of the beauties of this is that we can dig down and look at it, okay? So we have 110 firms in this UD law adopting states. And we can go and look at who the firms are and what they change. And one of the things you can also see is most of the changes here are either the adoption of a poison pill or a golden parachute statute. Which again, theoretically, you could say adopting a poison pill is related to entrenchment, right? And so you should have a lower value. But it has no relation to a UD law. Whether or not you adopt a poison pill before or after a UD law, without going into, and I'm happy to do it offline, for fiduciary duty purposes, you're not going to have a breach of the duty of loyalty or a breach of the duty of care that would actually sustain a case. So again, the link is tenuous here, but maybe we can assume there is. You could argue, you could challenge the adoption of the poison pill as a breach of the duty of loyalty. You would lose, but you could argue that, okay? And so we now have we've identified the changes in the E index, we've identified the firms, we have 20 changes which are higher, and what we can do then is we can go and we can actually hand collect the actual information on the adoption of these provisions. Like, were they adopted before the UD law was passed or were they after? This is harder than you think, right? Because EDGAR, which is the SEC database, only starts in 1996. We have to go to the microfiches, which still exist during COVID times, to try and identify when these provisions were adopted or not. Sometimes it's hard to identify, but it's not actually an easy thing to do, and it actually took us a fair bit of time to do, even for 20 firms. Okay, so we hand collect the information, and 20 of the 23 are miscoded. Okay, so 20 of the 23 are actually adopted before. I'm sorry. We identified 21 of the 23. The adoption dates were able, okay? Across the 20 cases, there are 23 cases. And we find, sorry, I got the numbers a little wrong. I'm still jet lagged 3 weeks later. 16 out of the 23 entrenchment provisions were adopted at least 4 quarters prior to the UD law adoption. So there is no way that this could be a product of the UD law. It's a year before, right? So essentially then we run some regressions. We correct the actual provisions. We only found now that there's 7 entrenching provisions. Even that's a charitable distribution because 2 of them we can't determine. We run the regressions again, and we find no effect. Okay, statistically, there's just no. We run it by each one, and we find that actually. I'm sorry again. The only effect that we have when we do a state-by-state analysis based on this is Pennsylvania. Okay? So now we have isolated the effect of the UD law change when correcting for UD laws, that only Pennsylvania has statistically significant results. But if you look at the coefficient, it's actually negative, which means it's negative, which means there's a decrease in entrenchment after the UD laws when you correct, which means that any effect you find of an increased value is just unrelated to UD laws or entrenchment generally. Okay, you might infer that the adoption of UD laws actually made you decrease the use of entrenchment provisions. Now this would be theoretically against Apple, right? Apple is, UD laws make it harder to sue, you're going to adopt entrenchment provisions, and so then your value is going to decline because you're more entrenched. What we find actually is there's a decrease in entrenching provisions post-UD laws. So whether or not you find an increase or value or not, it would be UD laws are positive. But we show no correlation or causation with those issues. And we find no evidence that actually the decrease in entrenchment provision is related to UD laws. And we can go through the actual changes now to do that. So what do we find? We find that the adoption of UD laws is associated with an overall increase in the E index. While Apple finds that, we find that prior evidence can't be generalized by state. We do a really deep dive, right, which is pretty technical and probably pretty boring, but essentially what we find out is that we can't causally link the E index changes to the adoption of UD laws otherwise. I think just one thing we do, which is we look at the returns for those firms in UD laws that adopted entrenching provisions. Most of them adopted poison pill provisions. And so one of the criticisms of the poison pill literature, which has found that it results in a decline in value, is, well, why would you adopt a poison pill when you always have a shadow poison pill? And the answer is because you have a steep decline in your stock price prior, and you're worried about activists coming in, so you're going to adopt a poison pill given that steep decline. And in fact, that's what we find, right? And the reason why this is also important is we run this with all of Apple's sample too, is basically what Apple is picking up when you do it is firms that have a sharp decline in value and adopt a poison pill, okay? Which theoretically makes sense because they're protecting from their sharp decline in a takeover, but he links to UD laws incorrectly. And I think that's it. Bigger issues. You have to be careful with identifiers. I know everyone wants to find a good identifier or a natural experiment. I think one of the things that's exciting about corporate governance literature right now is we're re-examining a lot of the key papers from 10, 20 years ago and finding that maybe they didn't properly either run their regressions, they're using miscoded indexes, they're using identifiers without a firm sort of channel or theoretical basis. And so that's all I got.
Thank you. Very interesting paper.